Should I just sit tight on the line then?
Is this Mr. Cline?
Yes, it is.
Yes, you should. I will let the Juneau in court know you are with us, and if they want to call your case sooner, they'll have to just activate our line. But thank you.
Okay, thank you very much.
And Bonnie, good morning. This is David Mallett. I'm on the line as well.
Okay, good morning. Did you hear we may be waiting a little while?
I did. Thank you. Also, Ms. Massey is not going to be able to make it. She just called me in a panic saying that she's snowed in and can't get in.
Okay, well, we'll have you tell Judge Pallenberg that when they get to us. Good morning. Who just joined us on the line?
Good morning. The Juneau courtroom. Who all is on the phone?
We have David Mallett, Leanne Bauer, and Trampus. We may be waiting a little while, as well as Jan Skyway Court.
Okay, so David Mallett, and then, sorry, one more time.
Leanne Bauer, Mr. Albecker, and Haynes, and I've got a 9 o'clock in Anchorage, so I don't know if there's any way that I could take a step and go forward first. I'm sorry, I've just got a really crammed calendar.
Yeah, unfortunately, so do we. So it'll kind of be up to the judge what happens, because we have about 20 cases on the calendar this morning.
Okay, if that
happens,
if that happens, I'm going to have to walk out, because I mean, there's just only so much I can do.
Right. All right. Who else is on the phone? Sorry, besides Mr. Mallett and Miss Bauer, who else is on the phone?
Travis Cline.
All right. Thank you, Mr. Cline. Okay. I'm putting you on to the courtroom. Like I said, we have a very packed calendar today, so just wait on the line patiently until the case that you are here for is called, and then identify yourself. Thank you so much.
How it works?
They have a very packed calendar.
Hey, was somebody...
I should have moved this. I do not know that I'm going to be able to make it.
Who's covering that one?
So,
Jonathan?
just to let you know,
I know that
they can take my case.
There was an email going around asking about oral arguments when started, indictment, and I responded I was fine with whenever, and I don't know that Amy did. I don't know. Do you know if the court did anything?
I don't have anything on there. I have a note.
It is very suspect whether or not.
So this is Trampus. Osborne just joined the call.
All right, thanks, sir. Thank you, sir. Just to let you know, we have a very packed calendar this morning, so just go wait on the line patiently until the case that you are here for is called, and then identify yourself then, okay? Thank you.
Oral argument.
Oh, it's just oral argument, not a hearing.
Yeah. So, wasn't sure if that happened. Yeah, Prince of Wales has turned into a 2-night trip every time.
I know. And it's usually
Well, the flights now are once a day.
It doesn't help me.
And they're at like 49.
I need dates.
Islanders, right?
I mean, I need dates when I know I can set a change.
Either one is reliable.
So.
Yeah, they're all
we have got to do this. So, for Mr. Berry, I don't know if this is a good date. January 17th. This is me. That would mean 2 cases.
All rise, students to your course, now touch on down to close that calendar.
Morning, you can have a seat. Got a full house this morning for a lot of pretrial hearings. My intention was to do the Juneau cases first and then the Haynes and Skagway cases. I understand that one of the folks we have on the phone has another hearing at 9 o'clock, and we'll take her case first. That's Ms. Bauer or Mr. Albecker.
Yes, Judge, good morning. I was wondering if we could go ahead and set Mr. Albecker on for a change of plea. Does January 15th...
Can you wait just a second until I make sure we have your client on the phone?
He's not on the phone. I'm on consent, Judge.
All right, then bear with me a second while I get to
No worries.
Actually, Mr. Albecker is here in the courtroom.
Is he there? Okay, great.
Yep.
Who's covering the what cases for the state?
I'll take care of
Ms. Kemp is here for the state, and you're asking for a change of plea. Is there any objection to the magistrate doing that in Haynes?
No, that's what it is.
I don't object.
So, Madam Clerk, do you want to is there a date and time you can give me for change of plea with the magistrate in Haynes?
Yeah, Ms. Bauer, did you have a proposal?
Yes, January 15th, change of plea date. If that works for the court and if that works for the state.
Yes, how about the afternoon of the 15th? Does that work, 2 o'clock?
That'll be fine.
Does that work for the state?
The afternoon of the 15th?
2 o'clock?
The 15th at 2, is that right?
Yes.
Okay, that's fine.
That will be with Magistrate Germain.
Okay.
All right, so trial next week will be vacated, matter set on for change of plea January 15, 2 p.m. with Magistrate Germain. Anything else on Mr. Albecker's case?
No, Judge, thank you very much, if I may be excused.
You bet, thank you.
Thank you.
All right, so picking back up with, I'm going to turn to Juneau cases. I'm just going to take them in the order they appear on my calendar. First on my list is Brandon Stevens. Mr. Headland, I believe, represents Mr. Stevens. My recollection was Mr. Stevens was off at treatment.
That is no longer the case. According to the probation officer, there's a warrant out for his arrest, and actually she showed me it, so.
And I see that. I signed a warrant December 11th. So...
In these ones, I would be requesting warrants, I would just say, how many open cases we have, but.
There's a warrant in the probation case 16-1285. There's not in the 17-891 case, which I think is a newer charge.
Judge, I would ask for $5,000 warrant.
Mr. Headland?
I haven't seen any of that. I'm in good with him. I've spoken with him.
There was a petition to revoke filed December, can't read the date, that alleged that, it was an amended petition because there was a pending petition, that he was terminated from substance abuse treatment due to non-participation October 29th. He failed to report to his probation officer November 28th. His current whereabouts were unknown. He was no longer employed and was no longer at the approved residence. But based on that petition, I signed a warrant. I'll issue a warrant in 17-891. The set bail amount of $2,500. And make that appearance bail. There's a $2,500 performance warrant in the other case. Trial
Are you getting warrants in both cases?
Well, there's already a warrant in the other case.
There's a second active, it's a misdemeanor case, but I see that it's set in front of you on
What's the case number? I don't believe.
1JU 17788.
Is that a VCOR?
It's a criminal trespass 1. I'm not sure why it's also scheduled.
It should, I don't believe it's assigned to me. I don't have the file, so I'm not going to issue a warrant. I don't know anything about it.
It shows in our system as being in your courtroom on your date, so I just wanted to...
I might have done a bail hearing on it, but I don't believe it's assigned.
And you vacated the trial, sorry, Judge.
Your Honor, can you just please clarify the bail for me? I got a little confused there. I know
Sure.
it's 2,500 in the PTR.
The PTR, previously, the warrant that was previously issued was 2,500 performance. In 17-891, I'm issuing a 2,500 appearance warrant, because he's not here this morning.
Yeah. Everybody.
Next case on my list is Mr. Poitra, State of Alaska versus Stephen Poitra. Mr. Poitra's here. Ms. Griffin's coming up for that one. This case, trial next week. Where do we stand on this case now? I know there'd been some discussion about the possibility of therapeutic court. Ms. Griffin?
There has been, Your Honor. It's something that is something that's still being considered by Mr. Poitra. I'm still trying to run it by the team members with JTC. There was a PO that was out for a period of time, or we were out without a PO and weren't accepting anybody, so it's still something that we're pursuing. Mr. Poitra is also pursuing treatment on his own. I'm here on behalf of Ms. McCauley, and I'm asking maybe if we could just have another month continuance.
Judge, I think that there may be some misunderstanding about where things lie. This was something, based on my conversations with Ms. Wolfstead, and she happens to be here, obviously, is that the team had already declined Mr. Poitra. And I think that was, if I'm recalling correctly, based on some previous attempts to try and just get him to participate with the program initially when we were pursuing that. So I don't think that that's an option anymore. And I'm pretty certain that was conveyed to the court last time, the court reflects on its log notes. So I know that Ms. Griffin is filling in here for Ms. McCauley, so I don't have an opposition to continuing a short period of time because we got a lot of other things next week, but I don't know that that's still the situation.
Ms. Griffin, anything else you want to say?
No, I mean, the last conversation that we had with the team for Mr. Poitra was that they weren't accepting anybody because of the lack of the PO, and we were under the impression that maybe it would be an option in the future, but if we're getting a hard and fast no, then I'm sure that's something that Ms. McCauley's going to have to speak to Mr. Poitra about more.
So, this is essentially the same conversation we had November 13th at the last pretrial. The defense said they were trying to get him into therapeutic court. The state said he's been told 3 times he's not on the list, not coming into the program, he's not opted in, and my comment, at least related in the log note, and I remember this, was if we come in at the next pretrial and I'm told you're still working on therapeutic court and the state is saying it's not an option, I'm not going to continue it again just for that. If we didn't have 20 or 30 cases on for trial next week, I would say this case should go to trial next week. Given the situation that both counsel are standing in today for other lawyers who are handling the case, and there are cases, I think, with higher priority for trial next week, I will continue it, but, I mean no disrespect to counsel in saying this, but it's been close to a year that we've been having continuances on the grounds that Mr. Poitra may be going into therapeutic court, literally for a year, because the first trial date was in January 2nd of 2018, and it was put off to allow time to explore therapeutic court, so I think we've kind of been there. Proposed to continue it to February 4th with a pretrial January 28th.
That works for the state.
Fine, thank you.
So, Mr. Poitra, your next court date at this point is January 28th at 8:30 in the morning.
What are those?
Pretrial January 28th, 8:30. Jury trial February 4th, 8:30. 4:45 is told for that. Next case I have on my list is Mr. Claassen. Claassen is here today. Mr. Singh, I believe, is representing Mr. Claassen there. I have a bunch of files here in front of me that are on, I believe, for trial next week. Mr. Singh, what's going on? What should we do?
I think this is an off the case. Are they on the line?
Oh.
I think they're.
Kevin Burke on behalf of the state.
All right, Mr. Burke.
Yes, Judge, and Mr. Claassen's been trying, I think, very hard in custody to get into treatment. He was working with the institutional PO, Ms. Tweedy, and as I don't know if everybody knows, she retired and kind of left him, lack of a better term in the lurch. It stalled his application process. So we've, in our office, we've been trying for the last week to kind of pick up the ball there. So I know we've continued this multiple times. Mr. Claassen is fairly serious about getting into treatment and, you know, kind of turning over a new chapter in his life. So I was going to ask for another continuance of a month so that we can see where we're at. And hopefully, you know, within the next couple of weeks, we can get the ball rolling on something. I know he's done a couple of applications. One of the applications he completed, I don't think the institutional PO turned it over to the treatment facility. So we're working on that and working on getting him a physical appointment set up so that he can get treatment.
Mr. Burke?
You know, I'm just reviewing the file, Judge. I inherited the case in November, but I know my colleague extended an offer in this matter back in July. I guess from the state's perspective, the state would like to know if this case is either going to resolve. Otherwise, we're going to be making preparations to go to trial. It's a fairly strong case for the state. You know, I don't predict this is going to be a very lengthy trial. This is probably a trial that we can get done in less than a trial week. So I'll defer to the court, although I would expect that by our next calendar call, the state's going to be seeking a firm trial date.
I'm willing to set it over one more time. Set it for the February 4th calendar with the pretrial January 28th. But I think we'll need to hear something definite next time, or we'll be proceeding to trial.
Okay.
All right. Rule 45 would be told for that period of delay. Mr. Norris next. This is Nyreal Norris. Ms. Carpenetti is here representing him. Mr. Norris is here. Ms. Kemp, is this your case? Case is on for trial next week. Should it remain on for trial, Ms. Carpenetti?
No, Judge. We're really close to negotiating an agreement. Ms. Kemp and I have been going back and forth on the details of that agreement, but I don't think we need to keep this on the trial calendar. I think what we probably ought to do is set a change of plea hearing out for a couple of weeks. It will be a felony. We'll need to set a sentencing too, but I think if we can just negotiate the last couple things, we can.
That's fine. Set for a change of plea, and I don't have a preference, so if Ms. Carpenetti needs a couple weeks, that's fine.
I would like, I sent a counteroffer to Ms. Kemp. She got back to me last Friday, and I was able to relay it to my client this morning, but I'd like to have a chance to talk to him a little bit more in depth about it, make sure he doesn't have any concerns, and give him time to ponder it. So I don't want to set it on right away.
Propose to set it for Tuesday, January 16th at 2:30.
That works perfect. Thank you.
In the event the case isn't resolved, then we'll put it on the next trial calendar.
What time?
On the 16th. Mr. Norris, you understand that? Trial's vacated next week. Next case I have on the calendar is Mr. Mitchell. I don't see Ms. Willoughby. Is she on the phone?
I believe Ms. VCOR is going to be covering for her this morning. She sent me an email yesterday.
All right. Mr. Mitchell, Soutier is here with Mr. Mitchell. Ms. Wolfstead's here for the state. This case on the trial calendar for next week as well. Ms. Soutier?
Ms. Willoughby is requesting a continuance for Mr. Mitchell. If we could go at least the next trial calendar.
I've got no objection to that, Your Honor. What I will note, and just so the court knows, as I've talked to Ms. Willoughby, I anticipate she's going to file a number of motions, so I don't expect that to be the actual trial date based on her assertions of motion filing, but I'm fine with doing that to make sure we get those motions filed and...
Understood.
keeping it on the calendar.
So would you prefer, I mean, I can put it on that February 4th date. It does not sound like it's a realistic date, but I can make that sort of a placeholder.
We could
with
either do that, or if you prefer, we could go out. Ms. Willoughby does intend to file those motions as soon as she can.
You have a preference, Ms. Wolfson?
I have no preference one way or the other. I'll defer to whatever works for Mr. Mitchell.
Let's just, I guess, propose then to set it for March 4th with the February 25th pretrial.
February 25th?
Yes. So trial be continued until March 4th, February 25th pretrial, and if that'll allow time, if there are motions filed, to have briefing and prior to that. Right, Rule 45 is told for that period of delay. Mr. Mitchell, free to go today.
Where's your next court date? And just give you Julia a call this week. Okay.
Next case I have on the calendar is Mr. Hasper. Mr. Hedlund, yes, Joseph Hasper. Do we have Mr. Hasper on the telephone? Ms. Wolfstead is representing the state on this case. Matter was set out last time we were here, and I think Mr. Hasper was going to go south.
Your Honor, he did so. We had email correspondence with him last week, and I probably should have arranged it earlier than this morning to try to figure out if he knew the number to call in on, so that might be an issue. Probably worth saying that our position is that he should never have been charged here, that he's innocent and would go to trial when he and the state are available, unless the state does something different. Maybe we could continue call tomorrow or something.
Maybe not tomorrow.
Oh yeah, maybe not tomorrow.
Ms. Wolfstead?
Your Honor, Mr. Hasper left the state certainly with the court's permission. If he's not here, we do have a trial date on for next week. I think the parties, especially with tomorrow being a holiday, need some sort of certainty about what's happening next week. What I would request is that the court issue a warrant, recognizing because he's in California, it's unlikely to be served. And if Mr. Hedlund can get a hold of him, and then we can set up a time to do a Claassen hearing and get it back on the calendar. But I think that makes a little more sense in terms of the timing and how we address this case moving forward.
Mr. Hedlund, you still expect we're going to be in trial come Wednesday?
I don't know. The state made a new offer late Friday, and I conveyed that to my client by email, but the emails were response kind of cryptic, so I need to talk to him, and we have a status this afternoon.
I would, I guess what I'd propose to do with Mr. Hasper is set him over till 8:30 Wednesday the 2nd, and expect to issue warrant at that time if he's not present by phone. At this point, trial will remain on for next week. Give me a second.
Would it be possible to get Mr. Whitty with him and at least so the in custody is good to go? I've got 9 o'clock, and I've also got Mr. Osborne from his building.
I can do that. I think because these are Haynes cases, though, I think Haynes needs to record. So
that's fine, or I can
it's fine. We can do that.
I can step out and then come back.
Before we go off record on Mr. Hasper, I guess I just want to ask one question because Mr. Hasper Mr. Hedlund, I've got one more question on Mr. Hasper. Because, so I know that the court has left the trial date on. I believe Mr. Hasper is still in California. I don't know if next week's the realistic trial date, but I've got 8 witnesses who are hanging on the line, and now we've pushed it to Wednesday morning. I think I told him an answer about whether or not, even if we get Mr. Hasper Wednesday morning, we'd be able to go next week.
Mr. Hedlund, you see him being here Monday if he calls in Wednesday?
Buy my ticket. We would make it happen if we needed to, but I'm fine with moving it too. I mean, we can agree now that
you all know better than I do whether there are other cases that we haven't gotten to yet that are still going to remain on for next week. So I don't know in terms of how many trials we're going to have next week. I mean, I'm comfortable saying it'd be at the end of the line of trials if there are other cases staying on, but I don't know whether that's going to happen.
I'm comfortable saying that if it doesn't have to go, and then we can talk about whether there's a warrant or resetting on Wednesday. I don't think the court needs to vacate the trial date today if I make a record saying that it doesn't have to go next week. I mean, we're the one who are asking the court not to issue a warrant yet, so.
I think that the state can comfortably not line those witnesses up for next week. I don't think I can take formal action without having him.
I'm fine with that. Like I said, I just, people keep taking weeks out of their lives, and I just want to make sure we're respectful of them.
Yep.
So, just to that point, to state the obvious, this job is sort of impossible because there's a bunch of things that are pretending to go simultaneously that can't all go. So we're all in that position all the time. So.
So, Ms.
Your Honor, I'm sorry, this is Ms. Bosman. I heard Ms. Soutier. I have the same problem. I have a 9 o'clock as well, and I have Mr. Milligrock, who's sitting in custody.
He's actually next in line for me, and Ms. Soutier stepped out to do her other hearing. So let's take Mr. Milligrock. He's the next case on my list anyway.
And, Your Honor, just so the court knows, the public calendar that's up is really confusing. It has 1442 as the call-in number for half the cases, and then the Haynes number for the other half of the cases. So that might be part of the confusion with your last case, just to put that out there.
Mr. Milligrock is here. Ms. Bosman is representing him. Is Kemp here for the state?
I am, thank you.
So this case is on trial next week. Should remain for trial. Ms. Bosman?
Your Honor, Ms. Sims' office notified me that one of their key witnesses was not available in January. So I have a problem. If we need to move it, I would suggest we put it on the March calendar.
Ms. Kemp?
What's the March calendar for Your Honor?
Well, I'm setting cases for March 4th. That calendar conflicts with Judge Shalley's March calendar, but that's the only week I can do it that month. So we have a little traffic jam in March, but that is contingent upon whether Laurent Graham goes on February 19th, though, which I think we don't know yet.
You may just take a couple seconds to March. It was the doctor who was available, I believe, usually the case.
I'll just say I'm setting cases for March 4th. If it turns out that I'm in trial on Graham on that date, I might ask if Judge Shalley can do any of my cases that are going to trial.
Okay, so it is the doctor that's unavailable, Judge. He looks like he's going to be in South America during the currently scheduled trial date. So the early March date would work, it looks like, for witnesses.
Ms. Bosman, March 4th?
That's fine.
And I take it from Ms. Bosman's statement, and I think that she has said this, but I just want to clarify that the defense is waiving the time.
That's correct, since it was initially our request to continue.
So, Mr. Milligrock, I'm moving your trial until March 4th. That does constitute the waiver of your speedy trial rights from the period of then. Do you have questions about that?
I would rather not, but I see that I don't really have a choice. It seems like it is not ready, apparently.
Well, we moved the case to date at your request the last go around.
I realize that. Yeah.
And because the witness isn't here,
Sure.
That is treated as a waiver of your speedy trial rights for that period of time. So I understand that might not be your preference. I know being in custody, I'm sure it's not your preference. March 4th for trial, 8:30. Pre-trial February 25th, 8:30. Bosman.
Thank you.
Next case I have is Jonathan Smith, State of Alaska versus Jonathan Smith. Mr. Smith is here with Mr. Singh. Case is on for trial on the week. Mr. Singh, should this remain on, to your view?
Well, there's a pending motion to dismiss, so I'd say no.
Normally it comes to me with a motion card clipped to the top that would flag that for me, and I did not have one on it.
I got an email
That's been pending quite a while.
Yeah, and I got an email from Keitha asking about setting an oral argument. I think that came up at the last hearing, and I don't think it's been done. I responded to the email saying, you know, whatever date she had suggested was fine. I forget what day it was. At this point, I'd have to hear a different date, because I think the date was December 26th was the proposed date, if I'm remembering correctly. So, I don't know what the court wants to do.
Right, I see at the last hearing a month ago, I said, we'll schedule oral argument. The file didn't come back to me after that hearing, so it never got scheduled. I'm sorry about that. I mean, I'll schedule it this week if you want for oral argument. I may have a jury trial Wednesday. I don't know, won't know till this afternoon.
Yeah, court's convenience is fine with me. I think my schedule's pretty free. I can shuffle anything else around.
Ms. Kemp, subject to the motion to dismiss, I mean, I could schedule this, I suppose, squeeze it in on Friday. Friday's pretty full, but I could do that. That still leaves the question, though, of whether the trial date should remain on for Monday.
So that's fine to set it on Friday. It's actually the Stage's case. That's fine, though. I think that she can get that done on Friday. As for the trial date, though, Judge, I mean, presented obviously a predicament. I don't know how Mr. Sting feels about this, but this, obviously the motion pulls Rule 45, so I guess I'd ask for a short continuance if we're going to assume that the motion will be denied.
Well, I'm not going to assume that it will be denied. But I guess what I propose to do is push the trial 2 weeks to the mid-January calendar.
That's the Prince of Wales trial week, and I've got a number of cases stacked there that I'm hoping at least one or two will go. I've got at least one client in custody there and a couple other with kind of pressing cases that need to get done, and I've been working on those. So I can't do it that week, but I'm not sure about the rule right now, because I think this motion's been ripe for some time.
Right, I didn't, when Ms. Kemp said that, I'm not sure that I would assume that Rule 45 is still told, because
It's been pending so long.
Yeah, the reply came in October 31st.
I mean, Ms. Wolfson makes a good point, the request for oral argument is...
And that's a question, I just haven't thought about that. There was oral argument requested and not scheduled.
I think last month the state made the same objection, and the court said this was the best case that I would set for oral argument. I think I covered the hearing. I think that happened a month ago.
I'm not sure what's being said.
I'm not sure what an objection to oral argument has to do with it. The defense requested one, and I said I would set it. So whether the state objected or not to it, I'm not sure what significance that has to the Rule 45 question.
I think we can take that up later, but I mean, I think my position would be that we've requested it, just like a right motion, you know, the rule starts running after 30 days. We've asked for oral argument. I responded to the court's, you know, request for availability. I don't know if the state did. And
well, then here's what we'll do. We'll have oral argument on Wednesday. Wednesday, January 2nd, 8:45 a.m. Trial will remain on for January 7th, pending an outcome on that.
And as far as trial, Judge, I don't know if the court would have, I don't know what the state, how long they think it's going to take. I don't think it'll take very long. But I've got calendar call down in Prince of Wales starting, I have to be there on January 8th. And that means I have to leave the 7th. I would probably have to come back the 9th.
I mean, that's fine. You don't get to have it both ways, though. I mean, if you're saying Rule 45 is running, trial set for January 7th, then I can't move the trial. If you want to push the trial out to February 4th, that's fine, but you'd have to waive Rule 45.
No, I understand that, Judge. I understand that. So wasn't trying to have it both ways. It's just explaining my availability. I was wondering if maybe just a day later in the week, starting on Thursday or something, would be possible.
It's not possible because I'm gone next Friday.
You're gone next Friday, okay. So at this point, I'm just not going to be available, so I think I'd have to ask that it be set to the 4th, and we'll see how oral argument plays out.
Ms. Kemp, trial be continued to February 4th with a Rule 45 waiver, pretrial January 28th, 8:30. I guess if we're going to do that, since I don't know if I'm in trial on Wednesday, I would propose setting oral argument for Friday at 9:30.
Okay, Friday.
Friday, January 4th, 9:30 a.m.
At 9:30, you said?
Yes. Let's turn to Mr. Hill's case. Patrick Hill. Mr. Hill is here. Mr. Headland. Mr. Burke, are you still on the phone?
I'm here, Judge.
All right. Mr. Hill's case is on for trial next week. Mr. Headland, should this remain on for trial as far as you are concerned?
No, Your Honor, we are not, I'm not ready. I guess the case is not that new, but to me, it's kind of new. I think the part I was out of town until, I don't know, October. And recently, we didn't have the grand jury indictment, the grand jury, and I got them and have now reviewed them and need to have time to see if there are any dispositive motions filed. So we're willing to take time. I was going to suggest practice of trial maybe for May.
That stuff too.
Mr. Burke?
Whatever they got for information.
Well, I just clarify, Judge, with my because I haven't had a chance to come. My state extended an offer back in November. That offer has since expired. I just want to make sure, and I'm not casting stones, but just for clarity of the record, that was indicated to Mr. to reject the offer because generally negotiations that included my cases for a trial track.
Practices. I've never had a discussion about an offer expiring or anything, so maybe we can talk about it some other time.
Just
prosecutors are different.
But if you didn't get it in your email, let me know and we can talk.
Okay.
So, what's the state's position on the request for a continuance?
No, I think there's a basis for continuance at this point. I'm not opposed.
I would, Mr. Headland, you were asking for May. I could set it, not opposition, I'd set it for April 15th for trial, April 15th at 8:30.
No
Mr. Headland, yeah. Is that okay? With Rule 45 waive, trials continue to April 15th, 8:30, pre-trial, April 8th. 8:30. That's your next court date at this point, but Mr. Hill, of course, stay in touch with your lawyer because dates change. And if you're going to need to come to court, Mr. Headland will let you know. All right.
That looks terrible. Yeah, I know. Let's go. Is that it? That's it.
Mr. Burke, is that your last case?
I think it is, Your Honor.
Thank you for being with us. You're good to go.
Thanks to the court. Happy New Year.
Next case on my list is Daniel Williams. I have State of Alaska versus Daniel Williams. Ms. Carpenetti is here. Mr. Williams. I don't see Mr. Williams.
I'm right here.
Oh, you are? Okay, I'm sorry. Should have recognized you. Ms. Wolfstead is here for the state?
Yes, Your Honor.
Ms. Carpenetti, should this case remain on for trial next week?
No, Judge. We are in the process of investigating several issues that have come up in conversations with my client. My investigator is in the middle of that work right now, so we're not ready to go to trial. I would like to ask the court, we filed a request for a bail hearing last week and haven't heard anything yet from the court, so I was hoping we could, maybe I just hadn't come to my office yet.
It's not in my file, so I'm not aware of that.
Okay.
I certainly can schedule one.
And I emailed Ms. Wolfstead a couple weeks ago, so to advise her we would be seeking a bail review request. I was out of town most of last week, so I had my assistant file it the morning of the 27th, which I know the court was closed half day. So I think maybe there was...
Right, am not seeing it. This week is really rough, but I'd propose setting it late in the day on Thursday the 3rd. 3:30?
3:30, Your Honor?
Yes. And Ms. Carpenetti, you're asking to set the trial off as well?
I am, Judge, yes.
Olmsted, do you object to a continuance?
I do not in this case, subject to witness availability and my availability. I know the court's been moving these to February 4th. I am out of state from the 25th to the 9th, and so I would need your later February trial date.
February 19th. Just note again that that is a date I'm scheduled to start a murder trial. There's been a request to continue. There's a hearing later this week on that. I don't assume that case will be continued. So we'll just cross that bridge if we get to it. Set the matter for trial February 19th at 8:30 with a pretrial February 11th at 8:30. Bail hearing Thursday, January 3rd, 3 p.m. So we'll come back Thursday this week for bail. Anything else?
The calendar call was at 8:30, Judge?
Yes. Anything else on Mr. Williams' cases this morning?
I don't believe so.
No.
What did you say was going to be not continued or whatever?
The trial is continued until February 19th.
Okay.
And then you'll be back here this Thursday for a bail hearing. Next case I have on for pretrial is Mr. Primmer, State of Alaska versus Gerald Primmer. Mr. Primmer is here, represented by Mr. Headland. Who's for the state? Ms. Wolfstead for the state. Case is on for trial next week. Should this remain on for trial, Mr. Headland?
Your Honor, I have a separate issue first. Mr. Primmer appears in custody. He was not in custody. He was at my office last week. He says he was arrested Friday. I hadn't heard anything about that.
Looks like I have a new file here that I actually hadn't seen before coming in here. It's in my stack. Looks like a VCOR was charged, alleging that Mr. Primmer failed to report as directed to PED for a urinalysis for alcohol. He was called the 27th and told, I'm just reading this from the charging document, so it's only the allegation. He was called the 27th, told to come in to provide a breathalyzer for urinalysis. He did not come in. PED officers went out and apprehended him, and I'm not sure if this is alleged as a basis for the violation, but it alleges that he was found in possession of 2 pocket knives. I don't remember if that was a condition of release or not.
He was seen over the weekend, Judge, and held on $5,000.
By who?
By
Magistrate Judge Curtin.
$5,000? And that's yours.
Ordered.
I don't know what's happened. People would typically be OR'd on VCORs. I mean, we're still in the same year. It's kind of hard to believe, but we're still in the same year of the first year of this new bail statute. It started January 1, 2018.
Complaint alleges that he failed to submit to multiple breathalyzers with requests. I think that was the reason given by PED why they went up remand.
May I say something on that?
No, please, one second.
What's the state's request today, Bob? Well, I guess we're in, Mr. Headland, you are asking to review that bail.
I mean, I didn't know he was in jail until I came to court, so I'm winging it a lot of times here. The state has an advantage over me. I think that his position is that there was something wrong with the breath machine. Does it allege that he was drunk when they...
It alleges that he was called and told to come in and he didn't come in.
Okay, but when they came to get him, was he drunk?
He doesn't say that. Doesn't allege that.
No. There was a couple times my machine registered a hot UA. He told me to come in, so I came in. They took a UA. I gave a clean UA every time they gave me
a UA. They tell me, they would call me on the spot, tell me that they wanted me to provide a sample. I would provide a sample. And sometimes the machine wouldn't even register a sample. I'd try like 2 or 3 or 4 times, and it just would not register a sample. I tried to tell the officer that. He told me flat out he didn't want to hear anything about it.
Okay. So, Your Honor, this is the type of VCOR that comes to this court, right?
Yes.
Okay. So I would ask that even if he gets 5 days, it would be 3 days, and he would have that since Friday served on the VCOR. So I would ask for that reason that the court OR him on the VCOR. I don't think that there's really been any communication with the state about how to deal with this case. Maybe there has been and I forgot, but I would like a chance to negotiate with the assigned prosecutor, who I don't even know who it is right now. I planned that if there was a trial coming in here that it would be Hasper, and that doesn't look like that's going to happen, so I'm a little bit flat-footed right now. But our request is that the court OR him on the VCOR and that we set trial out a couple months. I don't think there's been any request to continue this case. I think it was on a really pretty fast trial track, Your Honor. He was arraigned on 10/23, Your Honor. We had the omnibus on 11/19. So it's a pretty new case. Means we probably have had discovery for about a month.
I believe the last time we were in court, we had just received it.
Yeah.
So there's a bunch of issues there. One is a question about bail. Ms. Wolstead, do you want to respond on that first?
Certainly. I think that when the court is looking at the bail in the VCOR, it also has to look at the bail in the underlying case, and I think that's why the court started doing things this way, so that we can look at it in a holistic way. So, yeah, he's hit the 5 days on the VCOR, but then I think we also need to talk about whether bail should remain what it was at in the underlying case when he is alleged to not be following the conditions that you set there. And so I think we sort of need to address it more holistically.
So what's the state's position about what conclusion I should come to when I address it holistically?
And unfortunately, I don't have it in here. I'm trying to see what his bail was previously set at in this case that he was...
I think previously it was a 10% posting on $5,000.
Okay, so he posted $500.
Posted $500 cash. Performance.
Given the issues with performance, Your Honor, I think the court should either go back to the $5,000 on the underlying case or put a higher percentage of posting on there, given the issues with following the court's conditions.
So I asked to address bail in the VCOR, and the state's asking to address bail in the underlying case. Okay, I get it.
Well, bail is set in the underlying case. The temporary order that Magistrate Judge Curtin issued over the weekend listed both cases.
That bail is not, that the weekend magistrate said is not a barometer. It is irrelevant to what the court does today.
Well, it is a court order by a judicial officer, so it's not irrelevant.
It's irrelevant in terms of the court's consideration of the bail today. It is absolutely irrelevant. It doesn't mean anything. It's not a starting point or anything like that. The court has an obligation to view the bail anew. The whole point of the bail statute in SB 91 was to keep people who weren't convicted of crimes out of jail. It took like 6 months to slip back to exactly where we were before. My fear when SB 91, when this whole thing with pretrial services went into effect, was that it's just going to become a VCOR factory. And that's exactly what's happened. The point of the bail statute wasn't, okay, we're going to set bail so people who are, of limited financial means, who oftentimes have brown skin, who can't make even minimal amounts of bail, to keep them from being in jail before they're convicted. So now the thing is, they come out once, they have addictions or whatever, so there's one alleged violation and now they're back in. That wasn't the point. What would be the point of that? So, I mean, I think even a few months ago, people would have 3, 4, 5 VCORs. Maybe they'd plead guilty and get a few days in jail and they'd go back out. Then the court said, no, Now I want to have these sent back up to me so I can revisit bail in the underlying felony each time there's a VCOR, rather than just have it independently handled in district court. So now we're back up here, and we're on our first VCOR, and we're talking about reverting bail. He stayed in jail for a month, I think, on that $500 bail. I went and talked to his boss, got his paychecks, took them to the bank so that he could spend every penny he had to get out. He's been out. He met with me late last week, and there's an allegation that there's something funky with the breath test machine. Okay, what does that inform us about his guilt or innocence on the underlying felony? Nothing. It tells us nothing. So he's posted some amount of bail. He has been reporting to PED. Apparently they found him where he was supposed to be. I asked if there was an allegation that he was drugged. He said no. He's been in jail. He suffered a consequence. He's been in jail for 3 days over the weekend. And so I think under those circumstances, under the reinvestment study, under the whole purpose of the bail statute, Your Honor, you're supposed to let him out, and the presumption is to let him out unless it's not possible to do that. I've cited the court tons of bail orders that say, from the Court of Appeals, saying the court needs to use the least restrictive means possible. And the presumption is to let people out, if you can. So to come in here each time and reinvent the wheel and sort of just kind of push it back to, okay, now this scenario would not have been contemplated a few months ago. And I know that personally because our office has had 200 similarly situated people in the last year, probably. So I think that the court should OR him on the VCOR because, as I think I've argued before to this court, generally if a person has served the maximum sentence they can for the charge, they should be OR'd. And I've analogized it to the 3, 5, 10-day sentences people get for felony probation revocations for technical violations. And I just think the interest of justice is kind of, well, we're not going to hold somebody in jail just forcing them to take a plea awaiting trial on something. If they serve the maximum sentence, they should get out. So the only questions that remain are, should the court alter bail in the felony matter, and should we talk about a later trial date? Regarding the bail, for all the reasons I said, I think the court should not disturb the current bail setting. And regarding the trial date, as I said, I mean, we got this case in October. We got discovery about a month ago. I've since had a couple trials, and we've had the holidays. So it really has not been a whole lot of time to do anything. And I think that to adequately defend Mr. Primmer, I need some more time. So we're asking that the court OR him in the VCOR, which I haven't even seen the charge for. I don't know if he's been arraigned over the phone or however they do it. I don't know if trial dates have been set. And we're asking that the court not disturb bail in the felony matter, and that we'll take the time and move trial out a couple months.
You know, it's not, you regularly make accusations about conspiracies. The suggestion that the court moved VCORs up to this court in order to hold your clients in jail, I think misses the mark. It was done largely.
I didn't say that. It did not say that. I said so you could review it. It did not say that. Listen to the record.
Thank you.
I will not let this court tell me I said something I didn't say. You are free to quote what I said.
You're gonna let.
You are not free to characterize what I said.
You need to be quiet. I'm talking. You're interrupting me. You made a statement that came across that way to me. It's, I think, how any objective observer would take what you said, and it misses the mark. As I was saying before I was interrupted, it misses the mark because the primary reason that was done was because there were 2 public defender clients who remained in custody after district court hearings, and they were moved up here in order to make sure that that didn't happen. That was the primary reason VCORs came up here. So the suggestion that somehow this court is trying to keep your clients in jail misses the mark. Furthermore, the suggestion that everyone who violates conditions of release should be out on release, which is more or less how that came across, I think is a mischaracterization of the intent of SB 91 and the conclusions of the bail studies. The result of that research was that unsecured performance bonds one of the conclusions, are as effective as cash bail in obtaining compliance with conditions. If somebody violates conditions, then that suggests that the unsecured performance bond isn't accomplishing that result. It particularly doesn't accomplish that result if the unsecured performance bond never gets forfeited when there are violations. Here, there was a bond set that was 90% unsecured. There's an allegation that Mr. Primmer had multiple alcohol violations. I understand Mr. Primmer disputes that. I don't have PED here to talk about what led them to that conclusion, but the charging document says that there were repeated alcohol violations. I understand he says the equipment was malfunctioning, and maybe that's true. I don't have PED here to tell me their side of that. I have Mr. Primmer's side of that. I'm not sure that I can resolve that today. But he was then called and told to come in, and he didn't come in. Again, I don't have PED here. I don't know if there's an explanation for that. All I have is a misdemeanor charge that alleges that he violated conditions in multiple ways on multiple occasions. I can't just ignore that. I agree that after the 5 day, that given that he has served most, if not all, of the 5-day maximum for VCOR, it doesn't make any sense to hold him on that. And so I'm going to OR him on the VCOR. The question, though, is, do those allegations of multiple violations of conditions of release warrant some change in the felony bail? And I think they do. I can't say that that I'm meeting my obligation under the Constitution to protect the public if I just shrug and look the other way at violations of conditions of release. There are obligations other than making sure that every defendant charged with a crime is out of custody pending trial. So, I'm going to order on the VCOR, which is 18-15-19, that Mr. Primmer's released on his own recognizance. I'm going to order on the felony case that the previous 10% posting is a 20% posting. So, take another $500 to get him out of custody.
The court lowered bail because the state came in and said that the alleged victim had recanted, and the court thought that was compelling. I'd ask that this just stay on the trial calendar then. So I'll do a trial unprepared because my client can't get out of jail. And I'll remind the court that just earlier this year, but I think actually before Judge Meade, there was a co-defendant case with 2 people who were in jail, never got out of jail, who were in jail for 4 months pending trial, and were acquitted, and they don't get their time back. That's the reason. It's not about you and me. It's about, this is what the legislature wrote. It probably won't mean much in a few months, but it's the law now. And so the reason you set bail isn't because you need to send somebody a message because they violated conditions of release. The reason you set bail is because you think they're going to hurt somebody when they're out there pending trial, because the charges are serious, because the state's case is strong, because no other combination of things will assure them coming. The court's order is going to assure that Mr. Primmer stays in jail till any time he has a trial.
Ms. Wolfstead, stay ready for trial Monday.
Your Honor, I'm covering from a state, but I don't see any notes to the contrary, so.
Trial will remain on for Monday, January 7th, 8:30. I think that's the last Juneau case, if I'm not mistaken.
I leave you before every time.
I was at the last couple of hearings, but it's different.
We'll turn to the Haynes and Skagway cases. Just going to start from the top of the calendar. First, actually, we have one Haynes person in custody here, is that right? Remind me your name.
Okay.
What name?
Morgan, Judge Morgan.
Mr. Morgan, okay, I'm sorry. Mr. Morgan is here, represented by Ms. Carpenetti. There it is. Who's covering for Ms. H?
I am.
Ms. Kemp is here for the state. Matters on for trial next week. Ms. Carpenetti should remain on for trial next week in Haynes.
No, this is not going to go to trial next week, Judge. This case is similarly. I've retained an investigator to look into a certain number of issues. We're having some trouble securing the search warrant, so that's something I need to talk about with the prosecutor, though.
So the next Haynes calendar would be February 4th. Would that be what you'd be asking for?
Yes, Judge.
Ms. Kemp, any objection?
No objection to moving it, Judge. If there's some, maybe we can, is it a situation where we need to unsealed search warrants, or?
Yeah, and they're not listed on the indictment, and I've
Do you have the numbers, and maybe we could get the court to do that today, and the court would oblige?
well, no, that's the problem, and I
Okay, I got it, it could be a simple fix,
Yeah, I
we
don't
deal with it, but we'll deal with it, okay.
If there are any warrants that aren't unsealed, I certainly would do that. I don't have any numbers as well.
Okay, great, thank you.
So I'd set the matter over until February 4th at 8:30 in Haynes, pretrial January 28th. Actually, I'm sorry, pretrial January 29th at 8:30. That's the Haynes calendar. Pretrial January 29th, 8:30. Jury trial February 4, 8:30. Haynes. Yes. Anything else this morning on Mr. Morgan's case?
No, Judge.
All right. Mr. Morgan, you understand what we're doing this morning?
Yes, I do, thank you.
All right. Okay. Going back to the top of the Haynes calendar, first case is Mr. Osborne, State of Alaska versus Trampus Osborne. Ms. Soutier is here covering for Ms. Willoughby, for the state. And do we have Mr. Osborne in the courtroom in Haynes?
We don't. He was on the phone. Are you still here, Mr. Osborne?
Yes, ma'am. Yes, Your Honor. I'm here.
All right, Mr. Osborne's on the phone. Ms. Soutier, should this case remain on for trial next week?
Your Honor, Ms. Willoughby is requesting a continuance to the February 4th date for pretrial.
Ms. Kemp, is there objection?
You know, Judge, given the, way things are shaping out here in Cisco, we don't have an objection. It'll be a busy calendar.
Set the matter. Mr. Osborne, your lawyer is asking to move this off a month. Is that okay with you?
Yes, Your Honor. My only thing is I've been speaking with my attorney. I'm down in cancer treatment right now, and so I'm fighting stomach cancer, and I've just booked my ticket. I wouldn't have made my $1,500 round trip ticket knowing that it was going to be extended. I just found out just yesterday that it was being extended, and I'd already had my tickets pre-purchased. So in order for me to continue my treatment at benefit my health versus back and forth, I just would really like to get something finalized here. I know I probably shouldn't be saying anything, but I have to put this out there. This is a very serious matter on my end, and I don't have a problem with the February 4th program. I just really hope that we can, get this trial going and prove that there is a lying officer in the Haynes area that is provable lies. So at this point, I appreciate you hearing me, but that is my problem.
Sure, I hear what you're saying. I want to get this to a decision as well. But your lawyer is Ms. Willoughby. She's not here this morning, and Ms. Soutier is here standing in for her. And this sounds like there's
and that was a new thing to me as well, Your Honor. Like I just found that out yesterday.
Sounds like
I get that they're busy. I know they've got a big trial in Ketchikan or wherever they're at. But I need a little bit of update on my end as well. So I apologize for stepping in and saying something, but I just needed the courts to know that I am dealing with a very serious matter in treatment.
I understand. I hear what you're saying, and your health is the most important thing. Ms. Soutier, anything you want to say about any of that?
This is the first I've heard of the treatment. I don't know if Ms. Willow knew about it when she asked.
She does. She knows.
All right. I know it's going to be back on Wednesday, and if Mr. Osborne is okay putting this on the February calendar, I'm sure he and Ms. Willoughby can get together and try to find a trial date certain that would work with Mr. Osborne's treatment schedule as well.
Yeah.
We put it on for later on this week as a status hearing, that would work too. That way Ms. Willoughby can talk to Mr. Osborne, and if it's more appropriate to try to do trial next week, if we put it on for a status hearing on Wednesday.
I hate to leave uncertainty about that with travel. If I don't want Mr. Osborne to incur a penalty on changing a ticket, and I know that's expensive.
Your Honor, I just for the record, I am coming up no matter what on the 3rd. I have other obligations. I have some land that I'm trying to sell to an individual.
I can leave this on the calendar and have a hearing later in the week, but I don't know, Ms. Kemp, you want to
Well, I just,
say anything?
it puts us in a bind, because we ended up coming in here on Wednesday, and like I said, the calendar's all over the place. Sitka has had 98 cases set for trial, and Judge Pate was planning on running 2 courts. So that would encumber 2 attorneys from the state's office. We're sending one to Haynes, we'll be doing a trial here, presumably.
Do you know at this point if there are other Haynes cases that you expect to go, or maybe it's too early to say?
Judge, no, I think that, I have no idea.
I mean, if we have to go to Haynes for other cases, I suppose I can leave this on, but I don't want to leave it on and have everybody uncertain about whether there's trial or not, and the state uncertain about whether they need to have witnesses ready to go next week or not.
Your Honor, February 4th works fine for me. I just want to put it out there that I do have this very important thing, health going, so if it in the future has to be extended because I can't make it, then I can send all. Go ahead.
You know, the last thing I would ever want to do is interfere with somebody getting cancer treatment. So, you know, you can certainly feel comfortable that that would be important to me.
Sure. Thank you, sir.
But I'm going to set the trial over until February 4th, 8:30. Pretrial January 28th, 8:30. Make sure you check your lawyer about dates before you buy any more tickets, and I will hopefully work out any of these problems.
And what was the pretrial?
You're right, Your Honor.
I misspoke again on the date. January 29th at 8:30.
For a calendar call, correct?
That's right.
Okay.
Thank you.
Thank you, Your Honor. May I be excused?
Yes, you may. Thank you.
Thank you.
Next case on my list is Curtis Anderson. This is State of Alaska versus Curtis Anderson. Is Mrs. Anderson with us?
I don't believe he is. There's a consent to proceed in his file.
Should this case remain on for trial this week,
Yes,
Ms.
Your Honor.
Griffin? Did you say yes?
Yes.
So if we have a Juneau case, would need to, well, is the state ready for trial next week, Ms. Kemp?
So, Judge, I don't have an indication to the contrary.
So the challenge for me is I have to be gone next Friday, the 11th. If we have a Juneau case, and we do have one case still going in Juneau, plus a Haynes case, the gentleman in the Juneau case is in custody if that case goes. I think that would normally give it priority. I don't know that I can get 2 cases done in 1 week if I don't have Friday. So, I mean, I guess, I don't know what, if counsel have a suggestion about that, it would be trailing, I think, Mr. Primmer's case.
That's fine, Judge. So if it happens to be, if it's one judicial officer, then I think we can feel pretty comfortable when we're going, so.
We'll just leave it on for trial, but with the expectation that it's trailing the Primmer case, whatever happens with that. If we come to Friday and both cases are still on, I might set something up with counsel, maybe even Friday afternoon to coordinate, because there's travel involved. But at this point, it remains on for trial. Anything else this morning on Anderson?
Thank you.
All right. Next case I have is State of Alaska versus Miranda Massey. Ms. Griffin.
Good morning, Judge.
Mr. Mallett with us.
David Mallett.
All right. And is Ms. Massey with us this morning?
She is not, Judge. She called at 8:15 in the panic. She apparently is quite a ways out the road. She was stuck, apologized, but just could not make it. She gave me oral consent to proceed.
Is it your intent that this case remain on for trial next week, Mr. Mallett?
It is not, Judge. After very lengthy negotiations, very cordial negotiations, unfortunately, the state and I have reached an impasse on this, and it looks as though it's going to be motion practice. Illness, unfortunately, prevented me from doing it the past couple of weeks, but I should be able to get something in fairly shortly, within 10 days or so. Judge, if we could, I'd request at least a 60-day continuance on this to give the state adequate opportunity to respond.
Ms. Kemp?
Okay.
So I think that we will need to have a written consent to proceed in the file, and I'm a little concerned about taking action without Ms. Massey present. Well, I guess I would find that Ms. Massey's non-appearance this morning constitutes a waiver of Rule 45 based on her not being with us. I think I can set the matter over, and I will therefore do that. I would propose to set it for trial March 4th with a pretrial February 26th at 8:30. And finding a Rule 45 waiver. Ms. Kemp, are you in agreement with proceeding that way?
I think that's
Mr. Mallett is acceptable.
I am, Judge, and just to clarify things, I did get Ms. Massey's consent to continue as well.
All right. So the matter is continued with that. I would ask you to get a consent to proceed in file, and we'll reset it in that way. Anything else on Ms. Massey's case this morning? All right.
No, Judge, thank you.
Thank you. Have Mr. Jimmie's cases on the calendar. State of Alaska versus Charles Jimmie Jr. Ms. Griffin is here for Mr. Jimmie. Ms. Kemp is here for the state. We don't have Ms. Jimmie here. Is there a consent to proceed in these files?
Your Honor, I thought that there was. I wasn't here for his last pretrial. I think Mr. Hedlund covered it. It looks like there was a note that there was a consent to proceed. It may have been filed in the Haynes court. I'm not certain. However, if Mr. Jimmie's not present, I talked to Mr. Pulaski this morning, who represents him in a guardianship case. He gave him a call-in number. Wasn't certain.
Just double check. Is Mr. Jimmie on the telephone, Charles Jimmie Jr.?
And also, I mean, if he's not, he did tell me that he is on his way to Wrangell to move into an assisted living home. So the three of us have talked, Mr. Pulaski, Ms. Page, and I have talked about getting a resolution for this case. I think at least one of them is a criminal trespass and is alleged to have taken $2 worth of quarters. I think there's a lot of things that are related to Mr. Jimmie's mental issue with dementia, possibly. In any case, I don't think either of these cases are going to trial. I just think I need a little bit of extra time to be able to work with Mr. Pulaski and Ms. Page to get a resolution for Mr. Jimmie.
Ms. Kemp, do you have any objection to that?
No, I think that's appropriate. This one is a little different, though, because I'm not sure that the fact that he's not here is not explained. So.
Well, let me just say, there's a confidential case. I'm reluctant to say too much on a public record about a confidential matter, but I will say that there was a probate case before the court last week, and Mr. Jimmie was here in court. He is currently at Rainforest. There was testimony from a medical doctor in that hearing about his mental status, and the court entered some findings as to his capacity after hearing that testimony. And the testimony was consistent with what Ms. Griffin just said, that he is going to be entering an assisted living facility in Wrangell with hope that he'll be able to get back to Haynes after some work is done. I actually did remind Mr. Jimmie of the hearing this morning when he was here last week. I'm not convinced that, I think it was clear from the testimony that he would have difficulty making the appearance this morning and keeping track of his calendar to do that. Okay. So I'm not troubled, I'm not surprised by his non-appearance given the things that took place in court last week. I guess I'm not concerned by it. So I guess I'd be inclined to make the same finding I did with the last case, that Rule 45 would be waived by virtue of his non-appearance. I don't necessarily think other action is warranted. I certainly wouldn't issue a warrant for his non-appearance this morning, but I would find that speedy trial is waived, set the matter over. Should I just set it over a month, Ms. Griffin?
That should be fine. I would probably like to get it resolved rather quickly, so.
February 4th, 8:30, pretrial January 29th, 8:30. Anything else on that case?
No, thank you.
We have Mr. Hotch up next. State of Alaska versus Scott Hotch. Mr. Singh is here representing Mr. Hotch. Ms. Kemp is here for the state. This case is also on the trial calendar for next week. Mr. Singh, should this remain on?
No, because Mr. Hotch, I've got a little more work to do on this, but also Mr. Hotch has some oral surgery scheduled for Monday, and I'm also going to be probably in Prince of Wales.
Do we have Mr. Hotch on the phone?
Should be. I talked to him this morning.
Mr. Hotch, you there?
I'm here in the courtroom, Your Honor.
All right, good. Mr. Hotch is at Fort Haynes. And so are you asking to continue this?
I am asking to continue it, and I think this, hopefully if it's set for that February 4th date, should be good to go by then.
Kemp, any objection?
No, And obviously, I'm sure Mr. Singh would respect this, but subject to witness availability in the court. I couldn't tell what the witness availability is for that date.
Set the matter over till the February 4th trial calendar. Pre-trial is January 29th at 8:30, which would be Mr. Hotch's next court date. Anything else this morning? Mr. Hotch, any questions about that?
No, Your Honor.
All right, talk to you then. All right, next case I have the State of Alaska versus Jeremy Settem. I don't know if I'm pronouncing that right. Have a consent to proceed on file. I guess I just asked, do we have Ms. Settem this morning?
I don't believe that we do, Your Honor.
Fine. Ms. Griffin is here for him. Ms. Kemp is here for the state. Case is on for trial next week. Should it remain on?
No, Your Honor. Mr. Settem, this case, I think, is a charge of driving with his license canceled, suspended, or revoked. I've talked with Ms. Page, and she's agreed that if Mr. Settem gets his license back, she will dismiss the case. So we're just allowing him some additional time to get his license back. I think at least for now, if we were still going to set it on the February 4th trial date.
Can I make a different suggestion, since it sounds like he's going to get his license? If we give him if we set him to change of plea in 60 days, is that going to be an offense?
I'm not sure. I suppose we could do that, I don't know.
And then it just makes it clear for Rule 45. That would be my
That's
preference.
What if we just set it at the time of the February 26th pretrial, Haynes pretrials, since we'll be convening then?
That works.
I don't want to pile that up too heavy, but let's just do that.
What date was that, Your Honor?
Calendar the matter for change of plea, February 26th, 8:30.
Thank you.
Not setting a trial date since it's set for change of plea, Rule 45 is told. We have James Arendt, State of Alaska versus James Bradley Arendt. There's a consent to proceed on file. Do we have Mr. Arendt on the line?
Yes, Your Honor.
All right, thank you. Ms. Griffin represents him. Ms. Kemp's here for the state. Should this case remain on for trial next week, Ms. Griffin?
No, Your Honor. Again, spoke with Ms. Page. I've gotten all of the paper discovery for this case, but I think electronic discovery has been made but hasn't been picked up, so I am going to need some time to review that and then talk to Mr. Arendt about this. So just 1 month would be fine.
Ms. Kemp, any objection?
No.
Set the matter over for trial February 4, 8:30. Pre-trial hearing January 29, 8:30. That would be your next court date, Mr. Arendt. Stay in touch with your lawyer between now and then, okay?
All right, Your Honor.
All right, thank you.
Thank you.
And then I think we have the Skagway cases. State of Alaska versus Travis Cline. And I think...
We also have one more Haynes case, Mr. Whittington.
Ms. Thank you. Let's take that before we get to Mr. Cline. Ms. Soutier's been waiting patiently for Mr. Whittington. I think he was here and they took him downstairs, didn't they?
Probably.
Can we get Mr. Whittington back?
Okay. Mr. Whittington is in the courtroom in Haynes.
Oh, then we have the wrong Mr. Whittington here, I think. I know there are two.
My little brother.
All right. Yeah, right, Mr. Whittington in Haynes in the courtroom. Ms. Soutier is representing him. Ms. Kemp is here for the state. This case is on for trial next week. Ms. Soutier, should this remain on for trial?
Your Honor, it was my understanding Ms. Willoughby has entered an appearance. She's the one who appeared on the calendar, which is why I'm here today. She does not know about this, so it should not remain on the calendar. And perhaps I'm wrong, but if she hasn't entered her appearance, it might still be in conflict process.
But you're
Right, but the calendar that I pulled up had Ms. Willoughby, but I'd like to make sure that she was there because she did not know about this.
There's too many files up here and I'm not. Ms. Kemp, is there objection to continuing this?
Not, it sounds like Ms. Willoughby is new to the case, so on that basis, no, that's fine.
And I'm just making sure that she was the one who appeared on the calendar this morning.
I'll pull it up on court view. I'm not locating the file in my stack of too many files up here.
Yes, she's the one listed on the calendar for 1819. So, yeah, if we could continue this.
Oh, Judge, Ms. Wolfstead pulled up the entry of appearance. She did enter an appearance on 10/15 of 2017.
It's 2018.
Oh, okay.
You stated it wrong.
Okay.
Okay.
10/15 of 18.
Okay, then I think it's probably just falling through the cracks. If we could have the next calendaring date.
Ms. Camp, you said that's okay.
I think that that's okay, Judge, and subject to witness availability is what I would say, because I do not know the answer to that.
Mr. Whittington, Ms. Soutier is standing in for Ms. Willoughby this morning, and she's asked to set the case over a month until the February 4th calendar. Is that okay with you?
Yes.
So I'll continue the matter to February 4th, pretrial January 29th, both of those at 8:30 in the morning. So your next court date is January 29th, 8:30. Make sure you stay in touch with your lawyer between now and then. Anything else this morning on Mr. Whittington's case?
No, thank you.
Thank you, Mr. Whittington. You're free to go. All right, now turning back to Skagway cases, first of which is Mr. Cline. All right. Travis Cline, are you on the phone?
Yes, I am.
All right, good morning. Thank you for being with us. The matter's on for trial next week. Should this remain on for trial, Mr. Singh?
No. Yes, Judge. This should not remain on for trial. I'd like a change of plea date. And Mr. Cline would like something, I think in March, because he's working on hopefully having enough money to get on some ankle monitoring or something to serve his time.
Ms. Kemp?
I've got that case, Your Honor. We're
Wolfson.
fine with a March change plea date.
So, Madam Clerk, can we set a March date with Magistrate Germain? Is that acceptable to counsel to have the magistrate judge do it?
Felony?
It's a felony.
Yeah, it's a felony.
Oh, it would be a felony. I'm sorry. Apologize for that. I'll set it on my calendar then. This is was one of the two files out of this huge stack that I didn't have when I came in here this morning, so I don't have the file in front of me. Bear with me just a second. I would propose to set it Wednesday, March 6th at 2:30 p.m.
That was the state, Your Honor.
Sorry, what was the date again, Your Honor?
Wednesday, March 6th at 2 p.m.
It was 2:30, Your Honor.
2:30. 2:30. Thank you. So, Mr. Cline, setting a court date March 6th, 2:30 p.m. And is Mr. Cline in Skagway?
He's in Ketchikan.
Ketchikan. All right. What would the plan be for his attendance? Is he going to be in Juneau? Is he going to be in Ketchikan at that time? Do you know? The only reason I'm asking that is if he would be expecting to do it by phone from Ketchikan, I would have it done by Polycom.
Okay. Mr. Cline, can you hear me?
Yes.
Are you going to be in Ketchikan at that time? Or what's your plan? You have a right to be in court in person to do this, but we can also do it via Polycom, which is like a two-way video, if you're not in Juneau, if you're in Ketchikan.
The two-way video would actually be more convenient for me because I reside within Ketchikan.
Okay.
Any objection to him doing it over Polycom? So what we will do is I'll arrange with the Ketchikan court to have a courtroom set up for you where you can come in and they have the video set up there, and we can do it by video conference. It works pretty well, actually. You can see us and we can see you, and just makes communications a little easier. It works pretty well.
Yeah, that would be excellent. Thank you.
All right, we'll do that. You don't need to pay for a plane ticket just to see me. All right. I'm just making a note of that on the calendar. All right, March 6th, 2:30, and the trial next week is vacated. Thank you, Mr. Cline. You can hang up.
All right, thank you.
Next case I have is Kevin Grieser, Kevin Grieser Skagway case. Do we have Mr. Grieser with us this morning?
I don't believe so, Your Honor, but we do have a consent to proceed from Ms. Grieser.
This
The
case
court
remaining
should
on
have
for
a
trial.
copy. Actually, Your Honor, there's a pending motion to suppress. I believe it became ripe on December 3rd, but Ms. Page did file her response on the 21st. I didn't actually get it in my inbox because of the holiday until last Friday, so I first of all would ask the court for an additional time for my reply. And I think there was also an outstanding issue of setting an evidentiary hearing, too.
Ms. Wolfstead?
I've got this, Your Honor. So my notes in the file actually say that Ms. Page's reply wasn't late because I think at the 11/27 hearing, the court granted her an extension of time through January 4th to file that opposition. She did get it in a little earlier, so I would just note, I guess, for Rule 45 purposes, I certainly don't believe the motion at this point is right. I have no opposition to granting Ms. Griffin whatever time she needs to file her response, and then once that response, but what I would, I guess, request is sort of general timeline on when she thinks she's going to get that in, because we want to set the evidentiary hearing for after that response is in with the court.
It seems, first I'll say I don't have, my file is really incomplete. I don't have the last log note, and I don't have the opposition to the motion in my file. The nature of the motion is one that suggests that it raises factual issues that would certainly require an evidentiary hearing. And I guess I wonder if we should just set one now. I would ask, is this something that's would require, it's a Skagway case, can we, I'm hesitating because I don't know if we can do a polycom with Skagway. I don't know if an evidentiary hearing could be done that way, or are we going to need to go to Skagway for an evidentiary hearing? Ms. Griffin?
Your Honor, that's fine. Ms. Page's response probably shouldn't take me too long to reply to. I can get it done by the end of this week. I don't know if we want to just set the evidentiary hearing, well, next week, but there's trial. I would like to have it in Skagway, though, so the officer can be present in the courtroom.
Ms. Wolfstead?
That's fine, Your Honor. I'll note next week is a rough week for us, so I would request it not be next week. And I don't know if this is possible, but either, the week of the 14th or 21st.
And I believe the 14th is either your China week or Judge China week. I just don't have my actual China calendar with me, so I might have some.
Every week is just terrible on my calendar. Probably if I have to go to Skagway, then that means looking for a day that I can have the whole day, because that's kind of a full day commitment. Would be Friday, January 25th, would probably be the first day I could do that. Is that workable?
If we just want to go ahead and grab that, that's fine.
Certainly, if there's an issue with Ms. Page's calendar, I'll have her notify the court. I don't know if she's got any, well, actually, I can look at it right now real quick. Hold on. I just want to make sure she doesn't have any major felony sentencings or something that she needs to be here in Juneau for.
Probably would plan on taking the morning plane up. Obviously, flying Lynn Canal in the wintertime is iffy, so I don't know when the morning plane is this time of year. I mean, I'm going to calendar it for 9 a.m., but if the morning plane doesn't get you there in time for 9 o'clock, we'd start whenever the morning plane gets there.
That's fine.
And I've just looked, her calendar's clear that day.
I will have to check with the clerk of court or the magistrate in Skagway, the clerk of court in Skagway on courtroom availability, because our hours are normally very limited in Skagway.
And I see that this court that we already have next court date scheduled of 1/31 and 2/4 for pretrial and trial.
I just leave those for now. Did you say 1/31? That's not a normal Skagway date.
That's what it's written as on my file. It could be someone heard wrong. If we need to change it right now for whatever purpose to 1/29.
I would propose to set it on the regular
I think the last
calendar.
date that was in court view was today's date. Please.
I don't have that log note, so it may be that I set that, but it didn't get calendared if the log note didn't get to the right people. I'd just set it for the February 4 trial date, January 29 pretrial at 8:30. That's right after the evidentiary hearing, and so if we need to revisit those dates, then we can. Anything else on that?
If I could just clarify, Your Honor, I can have till the end of the week to file my reply?
Yes, you may.
Thank you.
All right. And then I have Mr. Osborne on a Yakutat case. It says here Mr. Osborne's in, oh, Mr. Osborne's here. It says in custody on the calendar, but I know he's been sitting here patiently all this time. Mr. Singh is here with Mr. Osborne. Who's here for the state? Ms. Kemp for the state. This case is also on for trial next week. Should it remain on for trial?
At this point, no, Your Honor. I think just my availability, and then I think the state, this weekend, I think I got a notice of 404B, intent to rely on 404B evidence, which changes some things in my mind, I think. I got to talk to Mr. Osborne about that. You know, I mean, I know the omnibus order says within 10 days of the order. I know we've been through this before. I'm not, I don't know what my recourse is, besides a continuance, when this kind of thing happens. But I believe the omnibus order says that, 404B evidence is to be relied upon, it's to be, noticed up within 4 days of the order. And I know that, this came up before when Ms. Griffin and I went to Haynes for that trial, and I know that, I think looking at the law, I think all I'm entitled to is a continuance. So I'm not saying that it can't come in. It's a little frustrating when these orders are issued and, that there's other legal mechanisms to sort of circumvent the order, for lack of a better term. But anyway, I'll stop. My request would be a continuance to the February 4th date.
Ms. Kemp?
I can certainly appreciate where Mr. Singh's coming from. I don't want to get necessarily in a tit for tat. What I would say is this is going to be something that I'm going to request the court revisit. I don't know if the court will be willing to, but the order and changing some of the deadlines. And, like I said, I'm not going to get into a tit for tat, but I think it's often the case that, for instance, motions come in late and we're receptive to that. What I will also say is these reports were discovered, the basis of the 404B evidence were discovered right around contemporaneously. I think I discovered them with the original reports in this case shortly after his arrest. So it's not something that necessarily is surprise information to the defense. It's now come in a formal notice. I agree, but it's not something that wasn't provided to them, the substance of the information, and has long been in their possession. So that being said, I can respect that Mr. Singh might need some more time, but I do think that, it's interesting because the rule, I'm going to expand a little bit here, the rule itself allows for 404B evidence to be noticed at any time, including during the course of the trial. And while that's not convenient, it's certainly something that by operation of the rule, we should have the ability to make application for those things outside the presence of the jury. That's all that's required. The omnibus hearing form was something that was locally generated to deal with, I think, the need to be able for the defense to be able to respond. So I guess it'd be one thing if it was a situation where we dropped discovery on the defense at the last minute. But I think it's a whole different thing when we provide that information and make application.
Can I just jump in and say, the order doesn't say that the notice has to be given within 10 days. It says the notice or a police report detailing the acts must be provided within 10 days of the omnibus hearing. So if it was in the discovery, then it does not sound like there's a violation. I think it's reasonable, given the notice, that the defense can ask for a continuance based on that. But if there's a police report, that's not necessarily a violation of the omnibus order.
It was provided, just for the court's benefit, I provided the police reports on 10/15, and the digital evidence associated with it was provided on 11/5.
But there's a request for continuance that's not opposed, so I'll continue the trial.
And I just can I clarify one thing? I thought the case law said that, I know the rule says one thing, but the case law says that due process requires, I think the Bingham line of cases says that this stuff, that the notice has to be provided before trial. So that's in case law. So I just want to make sure that we're all understanding that that's what the case law says, that you can't, this isn't something that can be done, at trial once we pick the jury outside the presence of the jury. I remember looking into this a lot when we had that issue up in Haines. And I was, kind of wondering myself, and I believe the case law is pretty clear. It has to be done before trial. No deadline is set in the case law, but it does say before trial.
Well, we'll sort this out if we have to. I would, in terms of when we continue this to, do you have a specific request for how far out you're asking?
Just the 2-4 date at this point. I understand we're stacking things there, but that should give me plenty of time to read and react.
Ms. Kemp, is that date okay as far as you know?
The only thing I can say at this point, Judge, is that I'll file a notice, although it hasn't been super effective doing that, but if there's problems, and there are 2 medical providers, I'll file a notice, so it's subject to witness availability, and I guess I'd ask for flexibility if they're not available for that trial date.
I'll just say we'll take that up then. Don't take the position now.
February 4th, 8:30, pretrial January 28th, 8:30. Rule 45 is told for that period of delay. Anything else this morning? Mr. Osborne, you understand what we're talking about? Kind of?
Yes.
All right.
Sorry, I'm still kind of tired.
No, that's fine. All right. You're free to go.
Just call you before then.
Yeah, call me before then.
I think that's all the cases, unless somebody thinks we missed one.
Okay. If you have to take these back up, okay.
You can go off record. Madam Clerk and Haynes, you think we got them all?
Yes, that was everything on my list.
All right, thank you.
The chairperson has disconnected. The conference will now end.